Hello everyone! Today we will be informing you about human rights and discrimination protections in the workplace. To further illustrate the topics presented to you, we will compare similarities between the Spanish and Canadian systems regarding our topic. To begin, it is essential to understand what human rights are. Human rights are the most basic rights we all share as human beings. They are universal and international according to the Universal Declaration of Human Rights, drafted by the United Nations in 1948. The value behind human rights are that they help protect human security and freedom, equality, and justice. Along with many other benefits, the enforcement of human rights around the world helps to protect marginalized or targeted groups from being discriminated against. In the Charter of Fundamental Rights of the European Union, it states that everyone is equal before the law, and any discrimination based on any grounds, such as sex, race, color, ethnic or social origin, genetic features, language, religion or belief, political or any other opinion, membership of national minority, property, birth, disability, age or sexual orientation, shall be prohibited. Looking specifically at Spain, the Spanish Constitution states a similar protection. In Canada, there are similar rules in place in the Canadian Charter of Rights and Freedoms that state, every individual is equal before and under the law and has the right to equal protection and equal benefit of the law without discrimination. This is very similar to the protections listed in Spain and outlines the importance of protections against discrimination in the workplace. A great question usually raised is, can discrimination ever be justified at work? Usually, the answer is no, but in both Spain and Canada, there are two exceptions to this rule. The first exception is referred to as a genuine and determining occupational requirement in Spain, or bona fide occupational requirement in Canada. This is when there is a difference in treatment. A protected ground is justified because the nature of a particular activity calls for certain requirements, and that activity cannot be reasonably completed otherwise. The second exception is referred to as positive action in Spain, or the duty to accommodate in Canada. This is when specific measures are put in place to prevent or compensate for disadvantages linked to any of the targeted grounds. A conflict that usually arises when discussing human rights in the workplace is the balance between protecting a business's legitimate interests and protecting the human rights of the worker. This is where the information about justified discrimination in the workplace becomes relevant, as it introduces the proportionality test. The proportionality test consists of 4 stages. 1. Identify legitimate objective. 2. The measure must be rationally connected to the objective it claims to achieve. 3. Select the measure that is least harmful to the freedom in question. 4. There must be proportionality between the harms caused by the measure and the benefits of achieving the important objective. If the situation fails to prove any of the 4 stages, then the discrimination is not justified. In Canada, there is a similar test in place. 1. The practice was adopted for a purpose rationally connected to the job. 2. The practice was adopted in honest and good faith. And 3. The practice is reasonably necessary to fulfill the legitimate work-related purpose. If the situation fails to prove all 3 points, then the discrimination is not justified. Both of these tests work to ensure that the employer is acting in the most reasonable and sensible way possible when putting measures in place that may discriminate some groups. As future employees and employers, it is important to realize that businesses should not affect human rights if there is no legitimate business need for it. Thank you for watching, and leave us any questions in the comments below.